Yes! Hello, my beautiful friends. What an amazing day it is, and welcome back. Boy, are we jam-packed. We've got two major updates to attend to. We've got a presidential executive order signing that we're waiting to unfold just minutes away. In fact, 29 and counting. This is according to the AP. They're going to have the live feed here in just minutes. So starting 3:30 my time, 5:30 Eastern time. This was scheduled a little bit earlier, but it has been bumped. And so we will return to that if you're looking for the latest there. We also have some Senate hearings going on right now, but we're going to focus on some legal updates today. And so as we wait for the president to come out, give us some more executive orders. If you were here with us yesterday, golly, that was like Christmas in February, where he came out and just indulged and really enjoyed the signing of this order decimating Jack Smith and his liaisons, who gifted him $140,000 allegedly. We know it was probably a lot more than that in terms of value. So the president coming out again, we'll come back on that. But today we've got two updates that I want to share with you that are pretty massive. So we'll go in this order. We're going to start by talking about this case right now because there's a deadline tonight. The clock is ticking on this one. This, of course, is about restoring the USAID funds. Millions, hundreds of millions, maybe billions were cut off. The judge said to Marco Rubio and to President Trump, pay them that money and do it by tonight. And the Trump administration just went hog wild, filed an appeal, filed a motion for a stay, filed motions for clarification, and they updated the court. And they told us that Marco Rubio himself has now stepped in, reviewed the contracts, and signed off on them. So that's coming up. Then we'll go into this case because there was a hearing today, and we've got kind of a modified AI-created transcripts that we'll go through today. I'll share with you. I think I have an interesting methodology for this that I'll share with you coming up. But Hampton Dellinger, the hearing on the preliminary injunction was today in front of Judge Amy Berman Jackson. And we did call in this morning. I did listen into it and have a lot of thoughts on it. But sounds like she's going to extend his position for at least 3 more days. And we're just waiting on pins and needles to see what the Supreme Court is going to do with all of this. So plenty of stuff to get to. Very excited that you're here. We want to welcome you. The tubes hopefully are getting nice and warmed up over there. And also invite you to become a member if you haven't become a member yet. We have amazing members only morning streams. Get to a bunch of stuff that we can't get to here. And you can join by going to watchingthewatchers.locals.com in your web browser, signing up there. We'd love to have you join us tomorrow. And tomorrow, the members only stream will be 1 hour earlier because your boy has an event, actually Thursday and Friday, 1 hour earlier. That's a little announcement there. So hopefully we'll see you 1 hour earlier tomorrow morning. All right. So without any further ado, kind of keeping our eye on the president. So let me make sure I have this queued up for us in case he emerges. It can key me off and we do not miss it. But we've got some interesting updates to get to today. So let's start right here with the USAID deadlines. Here we go. Democrats continue to fight for the money to be turned back on. This is the case in front of Judge Amir Ali, the man born in Canada and practiced in Canada for a while before coming down here and deciding that he was going to unilaterally take over the executive branch and tell Marco Rubio what to do. His name is Judge Amir Ali. He's out of the D.C. District Court, lower level, and he led a hearing that took place yesterday, and we do have the official transcripts from the court reporter that we'll review because this case is now going up on appeal. The Trump administration, after his order came down, and his order was very aggressive, it says, you pay this money and you pay it by 11:59 p.m. on February 26, 2025. That's today, the day of this recording. And the Trump administration, as soon as we saw that come down yesterday, we're like, oh boy, here it goes. And we were not let down. We had a short update yesterday, but boom, Immediately after this judge's order, which again is just basically opening up the floodgates for all this money to be turned back on from the State Department, from USAID, Trump immediately appealed, right? Said notice of interlocutory appeal to the DC Circuit Court, taking it up to the Court of Appeals, motion to stay this coming in on behalf of USAID, on behalf of Marco Rubio, saying, Judge, you can't do that. You have to stay this immediately. We're not going to pay it by midnight tomorrow night by the time they filed this. Notice of appeal also got filed. Transmission of the notice of appeal, requesting the dockets and the underlying filings and more. And then the judge came out and issued an order on the motion for a stay, right? So Trump came and said, hey, do not make us pay this. Here's why. The judge immediately responded, said, no, pay it. That happened today, this morning. And then what we see is a bunch of additional filings. So check this out. So Marco Rubio, United States State Department, and USAID filed all of these additional attachments. You can see large additional attachments, Exhibit C, Exhibit A and B, and a notice by the defense, in this case, it's the US government who's the defendant, about the actions of Marco Rubio in particular, which we'll look at, right? And all of this is happening because the clock is ticking. By tonight, this money, according to the judge, needs to be paid to all these individuals. And so the judge gave us an order on the motion to stay his demand to pay these so-called NGOs, nonprofits, the Global Health Council, whatever that means. Okay, it means Democrat fundraisers. But what happened is the judge came back down, right? Last minute, everybody's saying, Judge, stop this. We're going to appeal this. The judge came, he said, look, I already granted a TRO back the day before Valentine's Day, February 13th, finding that these so-called doctors had shown that Trump's blanket suspension, he writes, of congressionally appropriated foreign AIDS funds would cause them irreparable harm. Also said it was arbitrary and capricious under the APA. Didn't consider the immense reliance that were here at stake. Now, while the court did not grant plaintiffs the full scope that they sought, it did stop Rubio and Trump from continuing their blanket freeze. Over the nearly 2 weeks since, they say the so-called doctors have moved multiple times to enforce the court's order and hold Trump and Rubio and us, the American people, in contempt. Each time attaching evidence from these doctors, and we call them, the AIDS doctors, so-called, that the defendants have continued their funding freeze and evidence of irreparable harm. Now, in response, the court declined to hold them in contempt, but said, pay them their money. However, the court twice told Trump and told Rubio, to the extent that you have a blanket suspension, you are ordered to immediately, this is the judge, cease it and take all necessary steps to honor the contracts. Because remember, in order to cancel these funds, Trump issued an executive order, then Rubio issued a State Department memo, and that was one basis to cancel these deals. They said, well, the president ordered it, so you're done. They said, well, you can't do that, Trump, that's invalid. So the State Department went back, looked at the contracts, and basically every single contract, because it's the government, just boilerplate stuff, they just copy and pasted. Every government contract has, for example, clause G for cancellation. The government, U.S. government, hereby reserves the right to cancel this clause for whatever reasons, including national purposes or whatever. Okay, it's all boilerplate, blanket language. They all had it. Like, oh, perfect. Glad we shoved that in there. Thank you, contract lawyers. You earned it. So then they went back, looked at all the contracts, and said, oh, great. Okay, we're going to cancel the contracts based on the contract, not on anything that Trump ordered via executive order or anything that Rubio wrote in response to that. So we have an independent source to cancel these items. So the court then and their TRO overrode that. The judge said, well, you can't do that. There is no independent source. If you're going through and freezing these, unfreeze them. And we've been commenting on this every step of the way, saying this judge is just inching closer and closer and closer to the edge of the cliff, because eventually the judge is going to say, Rubio, write the check. And you say, whoa, judge, you're not the Secretary of State there, buddy boy. So neither Trump nor their notice of appeal nor anything else changes or challenges the terms of the TRO. So give them their money. Say they filed in the instant motion a stay. And again, the so-called doctors have said, we're still being frozen and it's going to cause severe harm and we're all going to die by the end of the week. They said that their motion is going to enforce only the most acute harm. And they say that they want at least the money for at least the work completed, right? So now their claim is kind of morphing. It's like, well, we've already done this work and we've already earned this money prior to February 13th. Remember, Trump came in on the 20th, issued the order subsequently thereafter. So they want like at least a month of pay after the fact, after it was ordered to be cut off. The date of this court's TRO. So pay us everything up until that date. Now, upon receiving the motion, and then Rubio went back and the State Department went back and started canceling contract by contract. So upon receiving the motion, and now 12 days since the TRO has been granted, the court held a prompt hearing, whatever. At the hearing, counsel for Trump acknowledged that the TRO foreclosed them from giving any effect or suspensions that were issued before February 13th. But I think that's kind of misstating it there, Judge. I think it's about that was issued before related to the executive order or to the memo from Rubio. The court asked counsel for the defendants, for Trump and the administration, if he was aware of steps to actually release those funds. He said, I don't know. I can't answer that. I don't run the Treasury. For this and additional reasons, the court granted the doctor's second round of motions to enforce this. Remember, the court ordered Trump to unfreeze the funds for work that was completed before February 13th, consistent with the order, gave him 36 hours to do it. The court made clear, although it was focusing on this aspect, it was not limiting the scope of its original TRO, ordered a status report. So Trump's basis for staying this appears to be that they can only partially unfreeze the funds. Trump's like, what? We can't even unfreeze this in like 36 hours. You gave us like, what? How much time? You want us to just start like dumping money out the window? What's wrong with you? This is not something that they have previously raised with this court. He's like, oh, well, you didn't tell me that it was going to take a long time for you to do this. And that is so, even though this is asking you to comply within an already articulated time frame. Any such schedule would have to take, you already have had 2 weeks to come into a compliance and you haven't done it. And so do it now. This is not grounds for staying this, and so just get it done. Trump's remaining arguments in the motion for a stay pending appeal demonstrate a shifting ground at this early stage, saying they say that injunctive relief here intrudes. Trump is saying this intrudes into the executive branch. How dare you come in and try to interfere with our attempts to minimize waste, fraud, and abuse? But the blanket suspension, the judge says, you're the one who's causing harm. This was congressionally appropriated funding, not for the specific entities that Trump has cut off. It's a pause. They've been canceled. The money's going to be spent as Congress appropriated it, just not for your little tranny events in the Sahara. Said they didn't even attempt to argue that the action was justified or whatever. So this is the judge against justified. It's not your interpretation to justify where the money goes. This is the judge's substitution of his own presidential prerogative for Trump's, and he is not the president. And to date, Trump has not adduced any evidence about the possibility of waste and fraud beyond conclusory statements, right? And again, that is not your job. This is not a trial for a criminal charge of waste that you are alleging. This is Trump's discretionary determination from his presidential prerogative under the Constitution. There's nothing in there about, well, the judge gets to say, well, the president should have run it by me and the judge thought it was a good decision, or the judge isn't elected by the American people, not accountable to the American people in the same way. Now, moreover, although Trump's motion to stay this refers to the prerogatives of the executive branch, it does so without offering any meaningful depth of analysis, and their arguments that the injunction under the APA is a sovereign immunity problem is underdeveloped. This judge is like, well, I don't really like your arguments, saying that the court is not even considering its own jurisdiction. That's not so. At a hearing, the court simply noted the purpose of the hearing was to understand their compliance, not to relitigate all this. However, the court at this stage considered its jurisdiction, saying, Trump, your undeveloped arguments at this point have not persuaded us that it's going to affect anything that I've done before. Saying the parties also requested a briefing schedule to develop these arguments, and under that schedule, you recently filed your preliminary injunction brief, and we shortened the deadlines and more. So the court is prepared to hold a hearing on both of these on March 4th and issue another opinion soon. The purpose of this relief is to return to the status quo, right? And the blanket suspension of the funds was likely arbitrary and capricious. Like Trump just made it up out of his booty. It's coming out of nowhere. Arbitrary and capricious. Did the judge see any of the stories about where the money's going? There's like, no, that sounds great. Perfect use of money. I love tranny comic books as judge. I go to Peru all the time. Says, indeed, and would have the opposite effect of rendering the court's TRO. So accordingly, the court denies Trump's motion for a stay pending the appeal. So in other words, that money still needs to be delivered by the close of business tonight, says Judge Amir Ali, born in Canada and then transferring here. He must be furious about that 51st state comment or something. But he's now taking control of the executive branch in ordering Rubio to pay that money and pay it now. It's their money. They want it now. So Rubio, of course, and Trump appealed all of this after, the judge ordered that after the appeal. Then Rubio dumped in some more stuff, including these attachments. And they're now invoking the power of the Marco. And here is what got dropped today after that order hit the docket. It says, all right, Judge, listen, this is Trump's clarification of a joint status report. It says, look, the defendants, the State Department and Rubio, stated in the status report that as of this morning, the individualized review process has been completed for the USAID and the State Department, and that Secretary Rubio has now made a final decision with respect to each award on an individualized basis, affirmatively electing to either retain the award or to terminate it pursuant to the terms of the instrument, which is the contract, or an independent legal authority, some other independent source, right, that we've been screaming about here for this entire time, that they don't understand how that works, as inconsistent with national interests and foreign policy of the United States. Okay, so now we have the Secretary of State. It's not Elon or Doge or some deputy somewhere. Rubio was nominated by the president and confirmed by the Senate. He has looked at every single stinking, disgusting, corrupt contract that the prior administrations handed and doled out to their sycophantic constituents, who are now so-called civil servants who are suing the government to turn their money back on because they care so much about the American people and our will. Servants. So Rubio, thank you for doing that. I'm sure he had some late nights looking at all these disgusting contracts. Oh my gosh. Can you imagine your stomach? You're like, how much? Canceled. Canceled. Yeah, canceled. I need to take a shower after these. What for what? In doing what now? We paid how much for what? How many? Throw it out, right? It's just constant. Now, the statement is true for grants and federal assistance and award obligations. In addition, although the State Department has completed the review process for all grants and federal assistance awards, there are still 297 State Department contracts that need to be reviewed. There we go. So that is a new declaration. Now, we also have one exhibit here, which is Exhibit 1. Additional guidance. Okay, all these emails are being flying all over. Look at all these people on this email. All at usaid.gov. Jamie sent this one. Hey, dear colleagues, I'm following up on the notes issued on 2/23 regarding award terminations to provide additional clarification, says Jamie. Awards in Tranche 5 are being terminated for the convenience of the U.S. government pursuant to a directive from Marco Rubio in his capacity as acting director for USAID and or with Peter Marocco, who is performing the duties and functions for deputy administrators of USAID. Now, the decision to terminate these individual awards is a policy determination vested in the acting administrator and the person performing these duties. And to effectuate this, all USAID contracting officers are subject to the direction of a procurement executive who is subject to the director and to the direction of the administrator. So this is the hierarchy. We understand there's questions about this and how court orders may apply. We have received direction and confirmation that the administration's legal posture is that these terminations do not currently conflict with any applicable court order. And as such, we've been directed to move forward with Tranche 5 terminations, independent source of cancellation. We will continue to monitor any new legal developments. Please consider this email for your files as the authority needed to cancel even more awards today. And if you have any questions, let us know. Please use this revised termination template if you got any questions about that. Dear colleagues, Here's more. Secretary Rubio has reviewed and approved a new tranche of awards to be terminated. This was Tuesday, yesterday at 12:30. Rubio, man, he's just out there. Cancel, 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 canceled, 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 constantly. The list of Tranche 6 awards is available here. To streamline this, we've adopted a new process. I will be assigning warranted COs responsible. We'll provide automatically generated termination letters to ensure more and more. It's all very transparent. Here you go, Judge. This is how we're doing it. Here's another one that got dropped on Sunday over the weekend. Dear colleagues, here Rubio is reviewing these. As such, we've received direction. So please note in the tracker and explaining exactly, okay, all the things they're doing. These are all the emails. I can't believe how long it is. It's 53 pages of this stuff, emails about the cancellation. So Judge, look, if you actually think the reason they're doing this, it's a dump. Oh, Judge, you think it's arbitrary and capricious, you whack job in your little orders there? Well, how about this? How about you take a look at 53 pages of all the emails back and forth of how we consider this and how the Secretary of State, who is duly appointed and confirmed, just like you are, Judge, and much more accountable to the democratic process than you ever will be, since you can only be removed via impeachment. You want details of how this is happening? Here you go. There's one tranche of it. Now, there's more here, of course. You can see there were additional documents, large attachments, and another declaration here. So this one came in, looks like it's probably going to be the declaration of Morocco. There it is. And here, let's take a quick look at this one. Now, we're still waiting for the president to emerge with some new executive orders. But here is what's happening with this one. Telling us, all right, Judge, since last night, and he just published this one for February 26, 2025. So Rubio and the State Department. Can we just, well done, gentlemen. They said, look, since last night when I executed a declaration, the process for individually reviewing each outstanding obligation has concluded, saying Secretary Rubio has now made a final decision with respect to each award, every single one. Rubio has now made the final decision affirmatively electing to retain either the award or terminate it, calling it inconsistent with national interest and foreign policy, saying notification letters will be distributed for the awards that are retained. Now, as a result, no USAID obligations will remain in a suspended state. So, Judge, we're not going to suspend anybody. You said unsuspend them. Remember, that was the order. Unfreeze them, unsuspend them. Guess what? We're not going to unsuspend them. They're canceled. Rubio looked at every single one of them and they're canceled. Thanks for playing. In total, nearly 5,800 awards were terminated and more than 500 awards were retained. You're all canceled. Get out. Trump saying defendants are committed to fully moving forward with the remaining awards and programs that Secretary Rubio has determined to retain. So there's nothing to unfreeze. They're canceled as of now. Now, since last night when I executed a declaration, the process for individually reviewing each outstanding State Department grant and federal assistance award has concluded. Rubio has made a final decision. The state is processing termination letters. Notification letters will be distributed for the retained award within 2 weeks. In total, 4,100 awards were nuked, 100 total retained. Of 711 contracts originally paused, so contracts different from awards, approximately 297 still need to be reviewed. The remainder have even been terminated or resumed. Now, Rubio authorized a bypass of normal payment processing procedures to pay the 10 plaintiffs' outstanding invoices for work performed before January 24th, 2025, okay? So they did get paid. So stop your crying about not getting paid. Trump came in, cut off the work, the fact that you kept working, and now you're demanding money for your wind down process. That's your problem, not the American people's. It is estimated that it will take 2 weeks for those payments to issue, but I've been advised that certain funds, like $11 million, Judge, they're still going to grift out of us, have been released and transferred to them this morning. So they're going to get their invoices up to the 24th. Trump took office on the 20th. Now, to date, the State Department will pay a total of $4 million to the two plaintiffs, HIAS and the American Bar Association. Great. The ABA. 24 for work performed before January 24th. Those are going to take 2 days to process. Now, as to USAID, Morocco says, and for these plaintiffs, my understanding is that many of the payments they have requested lack complete invoices with all the relevant invoice work. Well, of course. Yeah, it's probably fraudulent. Like, oh, wait. We have to actually like tell you what we did the work for? Well, we don't want to put anything in there. It says memo. Do we have to fill that out now? No, don't fill that out. Don't fill it out. This has made it difficult to understand and verify anything. Like, the fraud's over. Tell us what it was for. They're like, health counseling. Oh, really? Oh, yeah. Ocean Conservancy. Yeah. We're going to stop global AIDS. We're sure you are. Yeah. Now, as to USAID and for the plaintiff specifically, my understanding is that many payments are intermixed with other charges from the same vendor. No one can understand who to pay or what to pay for. Now, as to USAID and for these people suing, my understanding is that some of them submitted requests without names or specific members or vendors. It's just like they're opening the floodgates. They're going nuts. Everybody's like, just submit your invoices. Remember how it was like during COVID? It was like, get your COVID money. Get it before it runs out. Same thing happening, which again makes it difficult to understand and verify the requested amounts. Now, as to USAID and for the plaintiff specifically, my understanding is that they're now requesting more than $250 million across 200 separate payments to more than 10 individual entities. Creating new payments and verifying this info would not even be possible today, Judge. So they're not going to get paid today, okay? It's like ridiculous. 200 payments for $250 million, it's nuts. We've already canceled them. Contracts are done. They're officially canceled, so you're done. The State Department has already expended $21 million in foreign assistance funding since February 13th, Judge. They got their money, and so they can just take it and eat it. Now, here is the latest. So that was from the Trump administration to the judge. Judge, like, it's kind of saying, we're not paying it, all right? Like, we paid what we paid. But that other part of that money, the contracts are canceled. They want $250 million across 200 payments. We can't pay them because they're submitting fraudulent invoices. We don't even know to whom the money will go, for what it is. And we're not just going to dole out $250 million. All right, not going to do it. Rubio looked at every single contract individually. Here are blankets of filings for all of the things that we did. Here you go, Judge. Here's some more. Relationship, Exhibit 11. Here, this is unclassified. Here's another summary. It's all within the law, Judge. So nothing is arbitrary and capricious, and you don't have any decision or ability to cancel this from happening, to stop this from happening. So fun filing there from the judge in the District of, from the Trump administration. All of this, of course, is in the District of Columbia. And so we're going to keep our eye on this and follow this case to see if the Supreme Court steps in or what happens. Thank you for subscribing and joining as we do. Now, let's pause for a quick moment and see what is happening with the president, because should be getting close to getting scheduled or to launching, according to the AP. Let me check the White House feed just to see what they've got cooking for us. Fox News is telling us live soon. And we're looking for the official White House channel. Let's see what we got. It is let's see. Apologies. Let's see. All right, so Fox News has this right now for us. And the AP is waiting to start, like right now. But it's not live right now, so let's see. Here's what Fox News has for us. Let's listen in on this one.
Yeah, but it's good news in terms of some recovery efforts there. For more on this, let's go to Connor Hansen with this report.
After nearly 2 weeks in the hospital, Pope Francis is up and moving around.
Pope Francis. Oh, good. He's moving around. All right, so we're waiting for the president to come out. And the AP doesn't have a feed for us, but let me check this feed. See if the White House has one up. They don't have anything live yet. All right, so we're waiting for that to boot up. And so that is the latest out of DC. Now, I wanted to share this with you. We don't need to go through the full transcripts today because they're kind of old and moot now, but I do want to share this, that we do have the transcripts. And so they are on the mind map for the members right now, have access to the mind map. So if you want to check those out, the full transcript from yesterday's hearing is now available. We got that. We got Margot Cleveland is also doing some great reporting on this, and I think she shared the link to the transcript. And if you guys just want to grab the transcript, you can get it. It's at watcherlodge.com. There's a whole PDF section there, and so you'll see it pinned to the top. So this is the full transcript from yesterday's hearing, happening very quickly, and it was over Zoom. And it was a wild transcript. I read through it a little bit. It's basically a lot of what we've talked about, them reiterating the same arguments that they're all going to die and they have to have this money turned back on. And it's kind of mooted. It sounds like some of the money has been paid, some of the money can't be paid, and some of the money won't be paid. And everything's canceled. And so the judge can decide what to do. Okay. The judge can say you're ordered to pay money for bad invoices. You're ordered to pay money on canceled contracts, right? And all of this is just is baiting the judge into, I think, overextending and usurping the full power of the executive branch. But all of this, just to point something out I noticed when I was reading this earlier, is that this was all taking place on a Zoom meeting. They all zoomed in on this, and there was like technical problems, okay? So nobody could get access to the audio yesterday, which is why we reached out and got the transcript just for posterity's sake. But in this, there's like technical problems all throughout it. And I'm thinking to myself, geez Louise, man, the carelessness with which these people are just cavalierly debating about hundreds of millions of dollars on a Zoom meeting where the technology is hardly even working. It's just like insulting to all of us. We should expect so much more than what's happening here, where judges are just ordering money to be doled out to Democratic operatives. Not a good situation. All right, so let's see what else is cooking. Let me make sure we're not missing anything. The AP feed has not booted up yet from our end. This is what it looks like. As you can see, wait for them to fire it up. But nothing on quite yet. We're checking over on C-SPAN. Fox is on a commercial break. All right, so we got one other story to get to on the Hampton-Dellinger stuff. And I do have a transcript I want to read through. But while we're waiting for the president to emerge, let's say what's up. Hey, what's up? Fred Pedamonte just dropped a super chat. What's up, Fred? Fred says, hey, bought Johnny some great food today. Thanks, KB. Or Knox Bierman. That's what KB is. Thank you, Knox Bierman. And I know what that's about, Knox. That was amazing of Knox. Knox Bierman, defense attorney in Texas. Sent some nice love over to our friend Fred. Thank you, Fred. Great to see you. All right, so let's see who else is here. And then we'll get back into things. We'll just take a quick pause and say what's up to our friends. We got Donut. What's up, John? Thank you guys for clipping for us. We got some new friends to welcome in. Oh, hey, it's Drain the Swamp GIF in the house. Great to see you. Drain the Swamp. Crocodiles. Got to get out of here. Hey, Sue Esponte says, happy 10-month membo yesterday to me. Happy 10 months, Sue. We got a baby plus one. Oh, the Associated Press just kicked it back an hour. Oh, my goodness. All right, so check that out. The Associated Press just bumped it back an hour, so we might not... We'll do the next segment and see what happens. So they just kicked it back an hour. El Presidente Trump. Bumping it an hour back. Let me see if the White House or C-SPAN changed that up. Also, all right, so it looks like that's going to be a little bit away from now. Let's see if the White House has that changed. Or what their X feed looks like. Stand by. Looking at the latest from the White House. All right, not much. All right, well, we'll get to some video from the cabinet meeting. But let's talk about this. All right, so we've got a whole nother major update that occurred today. The battle over the so-called special counsel being shoved back into the Trump administration by a blue judge called Amy Berman Jackson continues. There was a major court hearing today that's challenging the strength of the executive power. Does the president have the ability to fire people within his own administration? Or can Congress and can judges shove in a duly fired individual called Hampton Dellinger, the person suing in this case? Can they shove him back into the administration? This judge says they can. They had a hearing on it today, and we were waiting for a decision, but we are not going to get one quite yet. So I want to walk through where we're at. The judge issued a new order, came down today, essentially punting this for a few days. The problem here is that the Supreme Court held the appeal from Trump in abeyance until today. And so the judge is saying, well, the Supreme Court was going to hold it to today. I need 3 more days to think about it. And now we ask ourselves, well, is the Supreme Court then just going to agree with this lower court judge and just agree to the terms? Okay, you need 3 more days, however long you need. We'll be here when you're ready for us. Just let us know. I don't know. But we are going to wait and see. But there was a hearing today that occurred, and the government, on behalf of President Trump, did a great job arguing that the president, via the Constitution, has to logically have the ability to fire this person called Hampton Dellinger. And by the judge shoving him back into the administration, that is a usurpation of the executive power. It's a violation of our constitutional order, and it is an insult to all of us. So we're going to go through what happened today, but this is the motion that the government submitted originally. This came in from Madeleine McMahon, and I'm going to read through a transcript that we generated from the proceedings today, and she is going to be the person who argued this. So let me just walk through some of the arguments so they make a little bit more sense. But she submitted this motion for summary judgment saying, look, we should win. There's nothing to debate here. They lose on their faces. And here's why you should find in favor of the government supporting Trump's firing of Hampton Dellinger, the special counsel who was colleagues with Hunter Biden. So they give us their table of contents and authorities, and they give us an introduction accordingly. They're writing this to Judge Amy Berman Jackson, a blue Democrat-appointed judge who has done everything in her power to keep Hampton Dellinger in this position, in our opinion, so that he could bring in other individuals as moles inside the administration. And we saw him announce that yesterday, saying he was filing requests to bring in others who've been fired for probationary reasons and bringing them back on so that they could support him in his court-sanctioned insurrection of the Trump administration. So here's what Trump's DOJ writes. Look, Judge, in the last 5 years, the Supreme Court has twice held that restrictions on the president's ability to remove principal officers like Hampton, who serve as the sole heads of executive agencies, violates Article 2 of the Constitution, which is the presidential power. In those cases, the single heads of, for example, the CFPB and the FHFA, 2 agencies, right, the Consumer Financial Protection Bureau and the FHFA, another financial housing finance agency, both of those violated Article 2. Now, whatever the agency, for the president to discharge his constitutional duty to supervise those, the president, they said, can remove the head of an agency with a single top officer at will, citing the Collins case, which we hear a lot about. So on that basis alone, Trump's not acting like a lunatic. Biden, in 2021, fired the single head of the Social Security Administration without any cause. And they let him do it. And since the Carter administration, the executive branch has repeatedly said that this type of stuff violates the Constitution. You can't have an office of special counsel. They don't live under a branch of the government. And that's not how the Constitution works. It's got to be nestled in somewhere. So thus, when the President Trump removed Hampton as the single head of the office of the special counsel, just like Biden did from the Social Security Administration, just like you can do with the CFPB, just like you can do with the FHFA, he did it again here. He exercised his Article 2 powers. And now Hampton has filed this lawsuit challenging that removal. He says, I'm a public servant, whether you like it or not. I'm going to serve you so hard and you're going to pay my attorney's fees. But because OSC is an executive branch agency that basically does executive things, Trump's actions were consistent with the precedent. He's allowed to do this. And the extraordinary relief that Hampton is seeking here, which is to shove him back into an office from which he was fired, an injunction forcing the president, is not available to him. He should not be allowed to do this. The courts may not issue injunctions against the president, which is what you're doing. And even when courts do not enjoin the president himself, the Supreme Court has long held, because their argument is like, well, we're not ordering Trump to do anything. We're just ordering the Office of Special Counsel to do something. Well, where does the Special Counsel live? Well, it's kind of an independent agency. Oh, it is? Yeah, because Congress created it. No, it's not. It lives under the executive branch, obviously. It has to live somewhere. It lives under there. That means it's under the president's jurisdiction. So it is enjoining the president. When you enjoin somebody in the president's administration to do something that is a core power of the presidency, you're enjoining the president. Saying, thus, challenges to removal have been litigated through back pay. He can go sue for back pay, okay, not to have his job back. For all these reasons, you should find in favor of Trump, she writes. Now, Congress established the office of the special counsel, giving us some background. Back in 1978, the office began as an investigative and prosecutorial board of the MSBP, as we've seen. It still is that today. Go to their website, okay? It says Investigative Agency and Prosecutorial Agency. It's not complicated. The office executes certain provisions of 4 federal statutes, and we know what they are. We've talked about them here. The office promulgates regulations, receives and investigates allegations of wrongdoing, brings disciplinary actions, and more. And so similarly, all of this gives them prosecutorial power. In fact, they have 129 full-time people at his office, $32 million in funding. They got 4,600 cases. That is below the average of 5,900 cases received in the 5 years before during the pandemic, and they expect to get back to that level soon. Now, the office is headed, they say under U.S. code, by a special counsel. That person is appointed by the president with advice and consent of the Senate. Joe Biden put Hampton Dellinger in there. Now, the special counsel has the statutory authority to appoint subordinate counsel and the constitutional authority to appoint subordinate agency personnel, going through the law. And we have this U.S. versus Arthex case as well, telling us the Civil Service Reform Act came out saying that the special counsel may be removed, right? They created this law. Trump can only remove this person for inefficiency, neglect of duty, or malfeasance. So the president has shackles on their removal power, which is illegal. Unless they want to amend the Constitution and shove that in there. You see, this is from U.S. code. That's not in the Constitution. That's Congress. Congress wrote that. And there's a lot of crap laws out there that are unconstitutional. Just because the president signed it into law doesn't mean anything. It can still be in violation of the law. And because this is the patty cake game that we talk about, it's a disgusting feature of our government that has manifested itself in that 2 branches, which are supposed to be separate but equal, and they're supposed to have an attitude with each other too. You know, F those guys in Congress. No, screw those guys in the executive branch. This is our power. No. That's our power. And they fight for it, and we got better for it, right? James Madison talked about this, I think, in Federalist 51, where he says, ambition against ambition, pit ambition against ambition. Iron sharpens iron. You've heard it put another way. What ends up happening is they play this patty cake game because nobody wants responsibility for anything because they're all cowardly, ineffective leaders. And they then create independent agencies, and we get hundreds of them, and they're all responsible for everything that's happening. And then they just pick the ones they like. And they create this little pseudo branch of government that is not real at all. And the Carter administration even realized this. Reagan said the same thing. And the government filed a brief in the Supreme Court saying, look, the president must have the power to remove at will the single head of the Office of Special Counsel. Like, it's no question about it. Now here, in this case, Hampton was appointed by Biden, October 2023, confirmed in February 24's final year. Then on February 7th, the director from the new White House ordered him removed effective immediately. You're fired early February. 3 days later, he filed a lawsuit. Later that day, he went into Judge Amy Berman Jackson, who we're going to hear from in a transcript in a minute, saying that he is going to be reinstated immediately. The court held a near immediate hearing before the government had even responded. Several hours later, Amy issued a, quote, a brief administrative stay, which is made up. That's why that's in quotes, made up, that would last until midnight on February 13th. So basically immediately for multiple days. That was from February 10th. So 3 days administrative stay. It's made up. Minute order. The court's order restored him to that office. He got access to his emails, all the things. The next day, the president designated another secretary as acting special counsel, but the order from the judge prevented that from happening because she insurrected the special counsel's office via court order. Now, Trump then appealed this to the DC Circuit, saying, please stop the lower court from doing this stuff. The Court of Appeals rejected it. In a concurring opinion, though, Judge Katz has said, yeah, this is not immediately appealable because the judge, in a fake way, called it a stay. It wasn't a stay. It was basically a preliminary injunction. But it's not. If it was a preliminary injunction, then this would all be appealable immediately because she's injuncting him back into his office, forcing him back in. She's like, well, I'm gonna stay the firing, and so he'll be just back in office. He's been fired and removed. She's putting him back in. But she's framing it differently, which allows it to be unappealable for this entire time. So they appealed it. The Circuit Court of Appeals said, no, sorry, you can't. I mean, it's not an injunction. It's a stay. Even though it's basically an injunction, I can't take this. So rejected it. Said, yeah, but you should. There was a concurring opinion about the appeal. Now, on February 12th, the court entered a TRO stating that from the date of this entry, he shall be the special counsel's, right? So she formalized it. He continued to be the special counsel. Trump filed an appeal again. On February 15th, the court dismissed that appeal for lack of jurisdiction and denied Trump's alternative request for mandamus. Judge Katz dissented, said, okay, now this time, this should be reviewable. Okay, this runs afoul, said the dissenting judge, of the long-standing rule. This is how it's always been. The courts may not enjoin or stop a president from the performance of his official acts. Like, he is allowed to do this, and you're stopping him from doing that. And now you're saying he can't appeal that? That's nuts. They literally usurped a core Article 2 power of the president, says the dissenting judge. He also noted, under Supreme Court precedent, Congress cannot constitutionally restrict the president's power to remove this person because it's clearly executive power, and there's no exception to the president's removal power because it's in the Constitution accordingly. He also stated that the equities weigh in favor of the government because Hampton can just go get his back pay. So you should have granted this. Now, on February 16th, Trump filed in the Supreme Court. On February 21st, the Supreme Court issued an order holding this in abeyance. Gorsuch and Alito dissented, saying this is the court commanding the president to recognize someone with whom the president wants fired, saying that officials who have contested their removals have generally sought back pay, not being shoved back into office. And so the rules are as follows. The president does have the authority to remove at will single agency heads, says McMahon. Your Honor, we know how this works. Time and again, the Supreme Court has said it's unrestricted. Article 2 of the Constitution vests the executive power in the president and directs him to take care. Applying this rule here, the Supreme Court has held, that the president must be able to remove at will sole agency heads, right? So she's writing to Judge Amy Berman Jackson right now, but saying we've knocked at the door on the Supreme Court. We're going there next. Supreme Court has already said under SELA law that the Constitution scrupulously avoids concentrating power in the hands of any single individual except the president, the most democratic and politically accountable person in the government, which is how it's supposed to be. Every time we have these agency heads all over the government, it dilutes that accountability. And that is by design. That's why they create them, so that nobody's responsible for anything. We're going to have a committee and just focus on an investigation. They go back to their constituents. We need an investigation. I'll continue fighting and send letters, blah, blah, blah. Who's responsible for that? You're fired and gone. We're doing it right now, and everybody's freaking out. Oh my gosh, wow, I got caught not doing anything useful for the government at the taxpayer expense. Now you're out. Single agency heads thus must be accountable to the president through at-will removal, and there are only 4 single agency heads upon whom Congress sought to confer this protection. The CFBP, which got nuked by the Supreme Court in Sela, FHFA, which got nuked by the Supreme Court in Collins, Commissioner of Social Security, which got nuked by Joe Biden. Thank you, Joe. And the special counsel here. And for some dumb reason, Judge Amy Berman Jackson can't figure out what the precedent is or how this all works. She's like, well, I mean, there was that one other case called Humphrey's Executor from the early 1900s. Great. Thanks, Judge. They said, obviously, look, the Supreme Court precedent forecloses any special exception for the special counsel. If you just read these rules consistently, if you can get rid of the head of the FHFA and the rest of them, then it's logical that we can get rid of the OSC. There's no other case law in contrast to that, other than Humphrey's Executor, which, as we'll see, they'll deal with. Now, start with the director of CFBP. In Sela, the Supreme Court held Congress had already violated Article 2 by granting tenure protection. Remember, this was, I think, Elizabeth Warren's little entity, saying that this person could only be removed for cause. The Supreme Court said, no, sorry, at-will removal. They extended it as well to FHFA. The court explained, look, the nature and the breadth of their authority is not dispositive, but the president's removal power serves vital purposes, even when the officer subject to removal is not the head of one of the largest and most powerful agencies. Saying, in short, Article 2 empowers the president to remove the head of an agency with a single top officer. And then came the Social Security Administration. After Collins, Sela Law Collins, Biden then came right in and removed the Social Security Administrator without cause. Just got rid of the dude. Bye. Didn't notify anybody, even though U.S. Code said he could only be removed due to neglect of duty or malfeasance in office. And liberals didn't sue over that one. But in supporting that decision, the OLC said, well, yeah, the Office of Legal Counsel themselves said, yeah, well, you can read it that way. If Collins says you can get rid of them and you can get rid of them under Sela, get rid of them under this one. The only court of appeals to have considered the question, the 9th and 11th Circuit, have both held that any statutory restrictions on the removal of a single agency head violate Article 2. But Judge Amy Berman Jackson can't figure it out. This court should not carve out an exception to the president's removal power for the special counsel, right? They would have to write it into the Constitution. The other cases say you can't limit that. You can't impede that. It's his power. It's his function. Crafting a special exception would contravene the other existing precedent that you've already laid down with good reason. The Office of Special Counsel is a prosecutorial and investigative agency. That's what they do. They issue subpoenas. They investigate. They go after allegations. They look at prohibited actions and more. They appoint officials and they do a ton of things. Those are executive functions, and those are big ones. So you better think that these are not legislative agencies. The DC Circuit, even in your court, Judge, has noted that the special counsel is a prosecutor of merit system abuses, likening it to a prosecuting attorney to a court, going through all these other cases in front of the MSBP, saying even the MSBP, where the special counsel appears, agrees it is an investigative and prosecutorial agency. Thus, the unconstitutionality of the special counsel's tenure protection has long been apparent. The executive branch has repeatedly objected to this. Even Carter and his DOJ said, because the special counsel would be performing largely executive functions, the Congress could not restrict the president's power to remove him. He works for the president. In 1988, Reagan pocket vetoed a bill that would have vested the Office of Special Counsel with additional powers, saying no. That legislation raised serious constitutional concerns because it was trying to insulate the office from presidential supervision and to limit the power of the president to remove his subordinates from office. You see how these disgusting Congress people act? Thank you, Reagan, for doing that. You're going to make it impossible for the president to remove the special counsel's subordinates? It's like creating a whole new branch of government. They don't follow the rules at all. And they got both houses of Congress to pass that and send that to Reagan's desk. Makes you sick. Says, and several years ago, The acting Solicitor General filed a brief in the Supreme Court explaining that on the government's readings of the precedent, the president must have the power to remove at will people of a single-headed agency. And that was in Collins versus Yellen. So this is nice because they're articulating to the judge, look, Carter, a Democrat, thought it was unconstitutional. Biden used it, fired his own dude. It's bipartisan. No one likes this power in the executive branch because it's illegal. So this court misapplied precedent, by the way, Judge, because couldn't figure it out. Said in its prior order, the court explained that the reason underlying Seila Law and Collins does not extend to the unique office and the official involved in this case, saying the OSC, Office of Special Counsel, cannot be compared to those other cases. But that analysis is backward, Judge. Supreme Court precedents recognize a general rule of unrestricted removal subject to only two exceptions. So the default is you can remove, not you can't. First, remember we had Humphrey's executor, which Pam Bondi issued the memo. They're not defending this anymore because it's illegal. The court concluded that Congress could provide tenure protection if it was a multi-member body of experts balanced along partisan lines that performed legislative and judicial functions and was not said to exercise any executive power, right? That was essentially the holding in that old case, Humphrey's executor, which again, it's illegal. It's unconstitutional. Legislative and judicial functions, I guess, they're trying to draw a line. But then that would be like an entirely different office than the special counsel, right? It's a totally different concept. But they're not defending it. Pam Bondi says it's illegal too. And for the judge to try to use that and apply that to this case is insane, quite frankly. It's not even remotely applicable. But let's continue. Second, the court has concluded that Congress could provide tenure protection. So in other words, that's one exception. It's like the president cannot remove somebody from a non-executive branch or non-executive entity. It's judicial and legislative. I'm like, okay, well, if it's not executive, then it's totally different than anything the special counsel is doing. Second, the next exception is the court concluded that Congress could provide protection to certain inferior officers with narrowly defined duties, citing another case called Olson and Perkins. Now, those two exceptions represent the outermost constitutional limit of permissible congressional restrictions on the president's removal power. And these exceptions are inapt. You can't apply those here. As this court has recognized, the special counsel is not entirely analogous to the Humphrey's executor case. That was about an FTC filled with panel members. It's not even comparable to the independent counsel in Morrison, because that was a separate statute which is gone. And Supreme Court precedents established a bright line rule saying the Constitution prohibits even, quote, modest restrictions on the president's power to remove the head of an agency with a single top officer, Collins. So this court has already distinguished Seila Law and Collins. Okay, it's different, Judge, than your interpretation. There's another office called the special counsel. You say that there's limited jurisdiction and there's a small subset of federal employees. And you said that there's not broad rulemaking authority and blah, blah, blah. But Collins doesn't support that at all. This judge is like, well, it's a special counsel. It's like small relative to everybody else. It's not that big of a deal. So it's kind of like the FTC. It's kind of like a multi-body panel. So therefore, we're going to use that exception and shove him in there. That's not how that works, Judge. The Supreme Court refuted that, making clear the president's power to remove sole agency heads does not hinge on the relative importance of the regulatory or enforcement authority of the agencies. They wrote it in the opinion. Look it up. So Article 2 contains no exception for limited exercises of executive power that are only affecting small groups of people, right? They just make it up. Well, it's not that big of a deal, so like it doesn't hurt anything. Yeah, it does. Follow the rules. And the special counsel executes multiple federal laws. They investigate, they subpoena, they do all sorts of stuff. So the court also later emphasized in Seila Law and others that the Supreme Court did not comment on the constitutionality of any removal. But a court, by announcing its decision, causes other problems. And so the prior case law is dispositive. So you also said that he's kind of similar. Okay, if he's not similar to the FTC back in Humphreys, then he's kind of similar to independent counsel. And those independent counsels were protected from removal. And the Supreme Court found that that was allowed. Yeah, but Morrison was about inferior officers that were appointed by a court of law, not a principal officer that was appointed by the president with advice and consent of the Senate, who leads a freestanding executive department and does whatever the hell they want. It's not the same, Judge. The court also noted that Carter and Bush signed the bills that give the Office of Special Counsel its current structure, saying it's not uncommon for presidents to approve legislation of things that are unconstitutional. No doubt about that. Look how quickly they signed the Patriot Act. They don't care at all. Most of what they do, you can argue, is unconstitutional these days. The court added, when concluding that President Biden could fire the Commissioner of Social Security, that they didn't address the tenure protections, right? They didn't even want to talk about it. But the legal opinion stated that there were prosecutorial functions and one president cannot bind another president and so on. But regardless, they say, look, their other arguments are meritless. First, they say he is an inferior officer. And we're going to see this in the transcripts that we look through. Saying he is an inferior officer. They say that's not true. Someone is an inferior officer only if he has a superior other than the president. Someone else who's the boss, like an agency head. The MSBP does not appoint the special counsel. Only the president can do that. It's a freestanding, quote, federal agency that is not contained within a subordinate or other agency. He has no boss. Now he's claiming to be an inferior officer. Even if he did that, even if he was an inferior officer, then he could be removed. In fact, there's another case called Myers. The Supreme Court held that Article 2 empowers the president to remove inferior officers. All this case law says that's great. He's allowed to do that. But he's not an inferior officer. He's the sole agency head. He's appointed by the president. He's got the Senate's consent. So he's a principal. Now, second, plaintiff argues that the special counsel plays a limited role and they don't resemble the authority of other principal officers who lead the other agencies. So it's different. Okay, you can fire the CFBP because, well, they have more power, or FHFA because they have more power. But the Collins could not be clearer. The Constitution prohibits even modest restrictions on the president's power to remove the head of an agency with a single head. It is broad. And then third, Hampton also appears to question whether the special counsel exercises executive power at all. Said it's a shared interbranch interest. So Congress is interested. The executive branch is interested, and so he kind of is living in this little bizarro land between the two that doesn't exist. Saying he also says that the special counsel ensures compliance with ethics and so on. Yeah, right. Well, that is a roundabout way of saying he executes federal laws, okay? Ensures compliance. What does that sound like to you? Execution of something. The very job which is subject to presidential control. And fourth, Hampton also suggests that the court should recognize a new exception to the removal power because he's like unique and they need independence, whatever. But nothing about this office justifies recognizing a new general rule of unrestricted removal. The Supreme Court has held the opposite many times, has cabined the two exceptions to the president's unrestricted removal power to the outermost limits of congressional restrictions. Like you're barely allowed to do this. We'll let you limit the removal of a board, but that's it, barely. Trump's people say for all these reasons, he was removed lawfully. Now, he should not be granted a permanent injunction, meaning that Hampton should not be ordered to be shoved back into office for several reasons. There is no irreparable injury. He can go get monetary damages. And this is more harmful to Trump and the American people than it is to Hampton. He's not entitled to reinstatement at all anyways. By the way, look at all these other people who sued. Everybody was suing for money. They got back pay, salaries, and fees. The rule is a problem. If a court attempts to reinstate a principal officer that's removed, it violates Article 2. The president cannot be compelled to retain certain services of a principal officer who he no longer believes he can entrust. Many members of the first Congress argued against requiring the Senate's advice and consent for removal of officers because it would risk limiting the presidency. Even Representative Benson said this during the first Congress. He said, if the Senate, upon its meeting, were to acquit the officer and replace him in his station, the president would then have a man forced on him who he considered unfaithful. Thank you, Representative Benson. And Representative Bunido argued. He said, but suppose the Senate shall decide in favor of the officer. What a situation is the president then in, surrounded by officers with whom, by his situation, he is compelled to act, but in whom he can have no confidence. And Representative Sedgwick asked rhetorically, he said, shall a man under these circumstances be saddled upon the president, who has been appointed for no other purpose but to aid the president in performing certain duties? Question. Shall he be continued, pray tell, I ask again, against the will of the president? The injunction, writes this attorney, the plaintiff seeks raises just this problem. Thank you, representatives from the founding father era. Says, an injunction would also exceed the scope of your equitable power, judge. You don't have the power to do this. You have no jurisdiction over this. You can't shove people back into power. Look at all these cases we're citing for you here. Look at this one. Look at this one. Look at this one. And even in the Dellinger dissent, even Gorsuch said that they're trying to bring up this writ of quo warranto and all sorts of other stuff that doesn't apply at all. Now, perhaps the most telling indication of this problem is that they're unaware, Trump is, of any previous case ever in which a court ordered the reinstatement of a single agency head after they were removed by the president. Never happened before. They just keep breaking precedent. Every time it's about Trump, they don't care. At most, a court in this district in 1983 effectively reinstated removed members of a multi-member U.S. Commission on Civil Rights because that court believed the commission functioned as a legislative agency whose only purpose was to find facts that could be used as a basis for legislative action. But it didn't exercise any power in its own right. It's only like an advisory board, right? That's no support here. This dude is exercising Article 2 powers. Now, he says that there's a long-standing rule that's preventing a court from stopping the president from firing somebody. But the president is the only official with the statutory and constitutional authority to appoint and remove. So therefore, he's wrong. What he's requesting is out of compliance. It would prevent the president from exercising his lawful Article 2 authority, where the Supreme Court has found it is maximum. Now, Hampton and his injury is also not entitled to recovery because there's no irreparable injury. He's lost his employment. He's lost his salary. What he can't admit is that he's lost the ability to act as a mole from inside the Trump administration, but they don't want to admit that in their pleadings, but that's really what this is about. Although a public official's loss of salary is a harm, loss of political power is not. He doesn't have a private right to political power and to his office. You could tell that also to the civil servants. Now, at bottom, plaintiff's claim to irreparable injury, say, well, I lost my power. That's not his power. It's the president's power. And taking it from the president and giving it to him is intolerable under the Constitution. Now, there's other cases that they cite, which is totally inapplicable. And the balance of the equities weigh in favor of Trump and the American people, telling us the balance of these equities weigh against his reinstatement. He exercises executive authority and the president does not want him there. The president is elected by the entire nation. Adding exceptions to this rule heightens the concern that the executive might slip away from the control of the people and into the hands of disgusting federal judges. This court previously stated that Trump failed to identify circumstances that explained Trump's hasty and unexplained action, or that would justify the immediate ejection of him. Saying a president may only remove people for certain reasons, negligence and other things. No, that's not true at all, Judge. Presidents may remove officers simply because they want to appoint someone else. That's it. And guess what? You cannot review that. It may not be reviewed by the courts because that is substituting your judgment for the president's. Well, it wasn't really a good reason. You didn't give us a good explanation for it. We don't owe you one. The court also previously remarked that the executive branch didn't have any harm if they kept him because of its narrow focus. Wrong. It is encroaching on Trump's power. That harms him massively. It's been a month of this. The Constitution prescribes they're all the powers of the president, subpoena power and more. And the public interest is not served by reinstating this guy. He's not going to be able to do his job. And after he leaves, everything that he's touched or been working on, this office is basically neutered for now, which might be the point of why they want this to happen. A court order reinstating him would cause further confusion. He's already been vacated. The president already wants somebody else in there. And so, for these reasons, says this amazing attorney for the Department of Justice, Madeleine McMahon, shout out, Civil Division, writing this saying the court should grant summary judgment in favor of the defendants, in favor of President Trump and the DOJ, saying that Hampton should be removed and Judge Amy Berman Jackson's preliminary injunction should find in favor of the Trump administration. So that is what was submitted. Now, there was a hearing that also took place today, and I want to walk you through how I generated this transcript. So as we know, if you go to the court proceedings, what you'll find in the DC circuit is that you can actually call in and listen to the hearings, right? There's a public line that's available, but they do have prohibitions against rebroadcasting the videos and reposting the audio because they don't want you to hear what's going on in there. So another solution would be to just get immediate transcripts by doing speech to text and then having AI create a transcript for us, which is exactly what we did today. So what I did is got the text from the hearing, which was publicly accessible, and it looks like this. And the reason why there is so much of it is because it's just text, and I was recording from two devices, and I started one, and there's some overlap in there, so there's more text than is necessary here. It's duplicate, but I'm going to get better at this process. But the point is, this was the raw text of the hearing, okay? Just like we could just, grab a transcript. Problem is transcripts are expensive and they're slow. So this is an alternative to that. So what we did is we plugged all of this into Grok, and I asked Grok to turn this into a transcript as close to verbatim as possible. And I think it did a pretty dang good job, if I can be quite honest with you. Here's what it looks like. So this is an AI-generated transcript of the proceedings today that was modified by Grok. It did, I think, a great job. It replaced even a lot of the poorly transcribed words, like when they said like "Cela," the transcription would say like "CELA," right? Like "Cela." But this knew what the case is and rephrased it with "Cela." So I think pretty dang effective for our purposes. And we're going to get some good details. So this is the hearing. Special counsel Hampton Dellinger trying to shove his way back into Trump's administration in front of Amy Berman Jackson, District of Columbia. This is a hearing on the preliminary injunction. Trump's administration wants the injunction to be invalidated, okay, to be dismissed, essentially, the case to go away, saying there's no basis for it to exist. In other words, what Hampton Dellinger is demanding, his position back, is an invalid claim, and there's no basis for forcing Trump to do the thing. Hampton, of course, wants the opposite. He wants the judge to put him back in there more permanently. We're all waiting with bated breath for the outcome of this proceeding because at this stage, the preliminary injunction stage, upon a final order here, it becomes appealable, and now we can go to the Supreme Court. We think the last time we knocked on the Supreme Court's door as a result of this case, they rejected it because we weren't at this stage yet. So this is what happened inside the courtroom today. Judge said something like this morning. Good morning, everyone. Let's begin. And the plaintiff, who is suing to bring Hampton back in, said the following. Say, well, Your Honor, what we've imagined, of course, subject to the court's preference, is that these are the suers, I'm going to be addressing the constitutionality of the removal provision, and another attorney, O'Crumbach, is going to address the remedy questions, okay, and the other equitable factors. So judge says, okay, that's good to know. Thank you for that. For the government, for Trump, Ms. McMahon is here. Good morning, Your Honor. Madeline McMahon here on behalf of the government, joined by Christopher Hall, Harry Graber, also from the DOJ. All right, good morning, everybody. Now I'm going to start with counsel for Hampton. And while I'm sure you have a lot to say, I'm going to start with some questions right now, if you don't mind. So I welcome them, Your Honor. Yeah, please go. Amy Berman Jackson says, all right, Judge. Obviously, the statute says the special counsel serves for 5 years. And, you know, what happened contravenes that. So that's count one, you said. And Trump's position is that the White House did comply with the law. It's not that the White House complied with the law. It can't be. But that the law is unconstitutional. Okay, they point the case law says in order to fulfill his duties, the president can remove people under SELA law and Collins. So why don't we start with SELA law, Mr. Plaintiff? Thank you, Your Honor, I will. You know, this case is not controlled by those holdings in the sense that they don't require the conclusion that the Office of Special Counsel removal provision is unconstitutional. They provide jurisprudential framework within which to analyze that question. Fancy lawyering. SELA law identified 2 circumstances in which for-cause removal restrictions are allowed. One is in the context of certain inferior officers, and we believe that applies here. Independently, SELA law indicated that single agencies that wield executive power can be unlawful, but it's exempted. The OSC is clearly exempted from that. And so in both respects, SELA law leaves open the constitutionality here. Its principles support that conclusion. Okay, we're going to get to that later. But since you raised it, let's talk about that here, says the judge. Now, I'm not sure I understand the inferior officer theory. What is this? Most of the reasons you suggest he is an inferior officer seem to go to the significant executive power issue. But the test for an inferior officer involves the fact that inferior is comparative, right? So the question, is there someone superior to Hampton that exists out there? The statute provides the president can remove him under certain circumstances. So if it's just the president, like if only the president can remove him, doesn't that kind of take your inferior officer off the table? I don't think it does, Your Honor, no. If I may, I can elaborate a bit. The Supreme Court has indicated that there's no categorical test for an inferior officer. Generally, you focus on supervision. We've talked about this in other cases and in SELA, but the OSC is limited in jurisdiction, only operating within the executive branch, like the independent counsel in Morrison or others. Limited term, limited effect, so it's just a tiny little agency, doesn't really matter. Well, I think these are important factors, says the judge, that go to SELA law, but I don't see how they go to the inferior officer analysis, which seems to depend on whether he has a superior. Well, I understand that, Your Honor. Now, I respectfully don't think the test is simply whether he was a superior or not. In Arthrex, the Supreme Court, citing Edmund, explained that an inferior officer must be directed and supervised at some level by others who are appointed by presidential nomination with the advice and consent of the Senate. Similarly, in other cases, they reviewed the PTO, and so Dellinger can't even make final decisions on behalf of the executive branch. He has to be reviewed. So he's more like, a smaller agency. Judge says, well, you're listing the factors here. Where are you reading that from? Sorry, Your Honor, I apologize. I started with Edmund, and then I pivoted to Arthrex. Edmund versus United States, 520 U.S. 651? Yes, Your Honor. Now, I didn't want to focus too much on this now because your inferior office or argument seems to relate to remedies while they're discussing SELA law and Collins. Now, I don't think he's an inferior officer. That's the end of it. If I don't think he's an inferior officer, that's the end of it. There's only one exception to SELA law and Collins, and that's based on a significant executive power. That's right, Your Honor. If you're not persuaded he's an inferior, I'll stop. But if he is, it affects both the removal restrictions propriety, since SELA law recognized the limits for inferiors in Morrison and remedies. The key reason we think he's an inferior officer is that he cannot make final decisions for the executive branch. In Edmund, the court emphasized that that the Coast Guard judges lacks power for final decisions, and so he's kind of like that. No decision he makes is final. Okay, says the judge, so that goes to the heart of the SELA law then. Whether you call him an inferior or not, I understand your argument. Let's return to your initial point. These cases don't require concluding that this removal provision is unconstitutional. Before Collins, is there anything else about CELA law beyond this? Yeah, Your Honor. The government suggests CELA law created an all but categorical rule. That's incorrect, as you said. You already said. The Supreme Court also highlighted the CFPP's broad power and said the OSC is smaller than the CFPP. It explained what's unique about this, and that effort would be wasted if this was deemed invalid. Judge says, okay, stop speaking so fast. Someone's typing this. Slow down a bit. I apologize, Your Honor. So he says, so look, CELA law doesn't say all for-cause removals are out of bounds. The court says, okay, well, when you're done with CELA, I'll ask about Collins then. He says, I can't wait to talk about Collins. I've had hours to prepare, this guy says. Usually it's days or weeks, but this is anomalous. CELA law, it distinguishes special counsel. It emphasizes significant power. He doesn't have that here. Here, he lacks authority to regulate private citizens. He doesn't make final executive branch decisions. The OSC isn't a pure extension of executive will. He reports to Congress. He enforces ethical rules and more. All this should be undisturbed. Well, direct me to the specific statutory provision that you rely on to argue he doesn't exercise executive power. He doesn't. Well, Your Honor, I will. It's 5 U.S. Code 1212A. He investigates prohibited personnel practices, brings petitions for stays, files complaints. And under this, if there's no complaint, he can investigate to determine reasonable grounds. And under this, he appears before the merit board, advancing his agency's position, not just requesting action. The judge says, what? You just listed like a bunch of prosecutorial things, like all that right there. Do those counter your argument? It sounds like all of that is executive, right? Does that counter your argument? No, Your Honor, because we don't claim he has no executive authority. It's just some. Like Humphrey's executor in the FTC, his functions are an intent to be more than the president's arm. He investigates, issues subpoenas, and brings complaints, but he can't enforce those, or he can't force the MSBP, which he appears in front of, to take the case. He can't force them. The judge says, oh yeah, that's right. It's important. The government says he's no more supervised by the MSBP than the Solicitor General is by the Supreme Court, which I think is nonsense. Judicial supervision differs than this. The special counsel, says the judge, can't definitively state the executive branch's view or enforce it without approval. That's not the executive power CELA law addresses. So this judge is like arguing with this lawyer. Exactly, he says. Thanks, Judge. The government misuses Trump versus United States on investigative power. That was about criminal law, not this civil HR ombudsman rule. Okay, well, the judge says, then Collins comes along. Now, Trump says it means a single agency head can be removed at will. Is that what it says? If not, why not? And how do you beat that case? He says, well, Your Honor, if that's what it says, we're in trouble. Fortunately, that's not what it says. Oh, you sly dog. In footnote 21, Collins distinguishes the office of the special counsel, stating it doesn't comment on its removal restrictions. The government's theory that Collins decided this is wrong. Until recently, the OLC distinguished Collins about the OSC as seen in its post-Collins rulings, and Collins doesn't announce a categorical rule anyways, so it's different. Well, let's focus on count one. Is that your main argument for summary judgment? Yes, Your Honor, though our pleading was belt and suspenders, count one is the most appropriate. What about the APA count, says the judge? Well, under Franklin in Massachusetts, the APA doesn't apply to the president, but to other defendants. It's unlawful agency action to treat him as removed when he remains special counsel by statute. We'd rest on count one if it affords complete relief. But wasn't this a White House action, says the judge? Well, it's complicated. You know, Sergio Gore sent the email saying, it sounds like I'm kind of injuncting the president. Isn't it the White House? Well, it's OPM. Sergio Gore sent the email. OPM was his boss. So we pleaded it broadly so we could put it in count one. Are you arguing the take care clause? No, Your Honor, not here. The Declaratory Judgment Act isn't a standalone basis for relief, right? Correct, Your Honor. We just pleaded that out of caution just to add in additional charges. All right, anything else before your colleague speaks here? One procedural point, Your Honor. We're in an unusual position with the TRO. Well, we'll address that at the end, and we'll come back to that. I'm aware of the ticking clock and external interest as well. So over to your colleague, right? So someone else. Good morning, Your Honor. Good morning. So if I grant summary judgment and you guys win as to count one, what am I declaring? What am I going to say? This is also Hampton's other lawyer. Says that the February 7th termination was unlawful and that Dellinger is in fact the special counsel. Is that what you want me to say? Exactly, Your Honor. That's exactly right. Yeah. So you say, I don't need to worry about Justice Gorsuch from the Supreme Court or his concerns that you're not enjoining the president, like you're not forcing the president to do something. Gorsuch is concerned I'm forcing the president to do something. You say it's just his subordinates, right? Correct, Your Honor. The TRO from your court doesn't even apply to the president, per your footnote, right? And the Court of Appeal says it too. But doesn't this still tell the president who the agency head must be? No, Your Honor. There's another case and another case. Courts have remedied unlawful presidential actions with subordinate officials before, so you can do this. Yeah, but the Swan case was a concurrence, right? And that was later adopted in Severino, says the judge. Well, the majority in the Swan case, Your Honor, page 977 to 978, it held enforcing removal provisions is a ministerial duty. And so you can remediate that by injunction. So you can put somebody back in because it's not a political thing. It's just ministerial. It's just like moving papers around. Well, why discuss equitable remedies if you're not seeking a presidential order? Well, we don't need to, Judge. Historical precedent from 1959 supports reinstatement here. He says, hey, slow down a minute. Okay, before Webster, what was that? Vitarelli, Your Honor. Now, you suggest a mandamus in count 5, right, due to an appellate interest to force this? Yes, as an alternative, Your Honor, running against subordinates. But why mandamus? Why mandamus if the statute targets the president? Why would we do that? It's labeling, Your Honor. Whether we call it an injunction or a mandamus, it's permissible against subordinates. And so that's what we're doing here. Well, what's the standard for permanent injunctive relief? And why is Dellinger's harm irreparable? Well, the elements are success on the merits, irreparable harm, no adequate legal remedy, Judge, balance of the equities, and public interest. So your TRO opinion notes this isn't typical either. This isn't a typical employment claim, right? Money can't restore his statutory role. But are irreparable harm and no adequate remedy the same? Are those the same things? Essentially, yes, Your Honor, and some decisions collapse those. Okay, anything else? Well, just, Your Honor, that the government's cases are preliminary injunction cases. They're not final relief. And so your TRO analysis holds. Okay, so just issue this preliminary injunction using the same logic that you did last time, and they can appeal it up, and we can continue to flesh this out. Judge says, okay, thank you. Ms. McMahon, Trump's DOJ. Hi, Your Honor. In seal of law, the court emphasized the president's need to appoint those wielding significant executive power. How does that apply here? Your Honor, the special counsel wields significant executive power. Even Judge Katsas in his dissent and Judge Gorsuch also said that. And the 1978 OLC opinion also likens his role to a prosecutor. So the DOJ themselves say the same thing. Yeah, but wasn't that a different statute then back in 1978? Well, yes, Your Honor, it was, but the same reasoning applies. Tenure was 7 years then. I think it was the statute you're referring to, but now it was 5 years. And they're still trying to insulate him from control, as in the other case, as is here. Now, seal of law, she says, found the CFBP's broad powers were problematic. Now, how is the Office of the Special Counsel comparable? Well, Your Honor, it's the same thing. Under 5 U.S. Code 1212, he investigates, he enforces, he litigates, he appoints officials, core executive functions. He does a bunch of it. Well, no, he just recommends, doesn't he? But he can't enforce or mandate MSBP action, can he? Well, his investigative tools are invasive, Judge, just like a prosecutor's. He exercises some executive power. Some of it's sufficient under seal of law. What did the Collins standard change seal of law's significant standard, at all? No, Your Honor. It actually clarified that any executive power in a single head makes for-cause protection of that head unconstitutional. The nature of the authority isn't dispositive at all. Well, how do you square that with Humphrey's executor and seal of law's focus on agency specifics? Well, Your Honor, seal of law, it limits Humphrey's executor, says it's only a multi-member non-executive body, and it has to because Article 2 invests all the executive power in the president. There's no choice. But the OSC is unique, says the judge. It reports to Congress. It reports to the public. It doesn't fit those same prior cases. But Your Honor, the Supreme Court in Collins disclaims that is relevant. It's not relevant at all. Policy arguments can't override Article 2. That's the Constitution. So you got to amend the Constitution. Well, why did the OSC have carve-outs then? Your Honor, that's a question for Congress. Courts don't decide unpresented issues. SELA law signaled that the FHFA, later ruled on in Collins, was this decision. The OLC's views aren't binding. Well, what about the legislative history in this case, says the judge? What are we going to see happen here? Do you know how these laws came into about? I don't, Your Honor. I haven't reviewed it, but I can supplement if needed. The OLC objected in 1978, and presidential signatures don't resolve unconstitutionality. Just because a bunch of other bonehead presidents came in here and didn't say this was a problem doesn't mean that it's fine. Well, the judge is complaining. Well, how can he protect whistleblowers if he's just removable at will? Your Honor, Article 2 allows for removal for any reason. It's part of executive supervision. That's just how it works. And I was thinking to myself as I was listening and hearing this, yes, and if Congress is upset about it and they think that the president did something unlawful, they can impeach him. They have that power, but they're giant babies who don't want to do anything. Well, we'll just a special counsel, but nobody's in control of it. Too bad. Do your job. It what's the public interest harm? What's the public's interest harm in keeping him? It undermines the president's accountability. The OSC can function at will, consistent with Article 2. He can be there, fireable, according to the president's terms. Well, do I have the authority to enjoin subordinate officials? She's like, well, what if he's an inferior? If he's not actually like a special counsel? Can I get away with it that way? No, Your Honor. It encumbers presidential power. Swan and the Severino cases address standing. They didn't address remedies. Equitable powers per Grupo Mexicano also excludes this relief, so you can't do that. Plaintiff comes back out, says, Your Honor, President Bush praised the for-cause provision. Okay, he loved this. So there were many other presidents who loved this. SELA law distinguished the Office of Special Counsel, and we explain how that worked in pages 18 to 26 of our brief. We also cite the historical reinstatement cases, so we have all of the legislative history there for your review that explains this is lawful. The judge said, well, the TRO expires tonight, and Rule 65B2 allows a 14-day extension for good cause here. Given the Supreme Court's abeyance and late briefs, do you agree that there's good cause for a short extension to the plaintiffs? Yes, Your Honor. It moots the TRO appeal, allowing for a reasoned final order. So again, she issued a stay, turned that into a TRO, then set the TRO hearing way out for the hearing on the preliminary injunction, which is today. Then she says, wow, I don't know. Whew. So he's been in office for 2 weeks now. He's going to make it another 2 weeks, or we'll see. She's going to make it 3 days, essentially, but says, well, I need more time. So how about you, government? Do you agree that there's good cause for a short extension? No, Your Honor. Thank you, McMahon. It intrudes on Article 2. It's causing irreparable harm. The judge says, well, I'll consider that. But rushing a ruling here seems inconsistent with my duty. And so this case remains under advisement. And those proceedings concluded with that final statement from the judge. And so once again, this transcript was created via Grok using AI and was taking a raw speech-to-text translation and making a transcript out of it. That's the disclaimer, so take that for what it is, but it seems pretty accurate to what I heard today. So very interesting stuff there. Now, after that proceeding, the judge came out and issued this order. This dropped today, fresh out of the oven, 5-pager, explaining, as of Friday, Hampton Dellinger was appointed and in his office as the Office of the Special Counsel. Then at 7:22, Sergio N. Gore, identified as the assistant to the president, director of presidential personnel, identified him and informed him, you're fired, without identifying any reason, right? The judge is like offended. I can't believe it. Didn't even tell you why. He didn't tell you why? No. Then on Monday, Hampton sued to challenge his termination. On that date, the court entered a short administrative stay that she made up to preserve the status quo and saying, we're going to keep the same regime in place. Shoved him back in so he could access his email and their hard drives. On February 12th, the court issued another TRO. It then was entered with notice to the opposing party, says, we're going to hold this in line. We're going to shove him back in this administration all the way up until today, the date of the preliminary injunction hearing. The court then scheduled the hearing for for a date of 14 days later. So he could be in office that entire time. That happened today, February 26th. Given the terms of these rules and understandings expressed by everybody, the temporary restraining order expires today. Now, when the TRO was issued on February 12th, the Hampton had not yet had the opportunity to reply to the opposition. So I couldn't establish a briefing schedule. It directed the parties to inform the court of their position and more. In the meantime, they filed a notice of appeal. Then we got joint status reports. Based on that submission, we got expedited cross motions and a bunch of stuff. We covered a lot of it here. Now, it also informed the parties, we're going to be incorporating this here. On February 15th, the Court of Appeals dismissed this, saying Hampton remains in. On Friday, February 21, 5 days after the application was filed, the Supreme Court said, we're going to hold this in abeyance. And so now that's where we're at. Now, I know I'm not supposed to exceed this for a long time, but if there is good cause, then I can extend this even further. Now, I don't know what the general timeline is, but we're going to extend it for not longer than 28 days. Now, this court is well aware that this case is the very unusual posture of being subject to an application before the Supreme Court. Before the United States Court of Appeals has had an opportunity to review this, it also recognizes that the Supreme Court, with the understanding that the TRO expires tonight, is holding that application to SCOTUS in abeyance, right? They're not like this is waiting at the Supreme Court's door right now. They were waiting for this hearing. So it is incumbent upon this court to resolve this matter even more expeditiously, and we're going to work on that. Now, given the significance of the constitutional questions presented, because she created them, though it is also incumbent upon this court to give full consideration to all of the arguments in today's hearing. It is also necessary to give close consideration to all the pleadings and to rule on the questions raised after appearing here. This includes their 30-page motion that we just read today, which advances arguments concerning the court's authority to impose equitable remedies, and Hampton's 40-page opposition in March. Like, I have so much to read. And so this is particularly true. It's all been consolidated. Now, at the hearing that we just read through, the courts solicited the parties' views on the matter. The Hampton agrees that a short extension would be appropriate. He said that once the TRO would be vacated, then Trump's appeal at the Supreme Court would be moot. Now, while counsel for the defendants indicated a lack of familiarity with legislative history, she voiced objection to any extension of the TRO. This judge is just something else. Now, in consideration of all of these circumstances, then the court finds pursuant there is good cause, of course there is, to extend the TRO for 3 more days through Saturday, March 1st. So Hampton can keep shredding files so that the status quo will be preserved, so that the judge can write a written opinion and read all of the things. Because she's like, I'm so busy this week. Amy Berman Jackson, a blue Democrat judge, continuing to usurp the executive branch of its lawful authority to manage its own agency. And so we're going to keep our eye on that one. Thank you for subscribing and joining as we do. Now, we were paying attention to President Trump, and he has bumped it again. So we got bumped an hour, and that was an hour ago, and now we got bumped again. And so as you can see here, not exactly sure what's going on over there. Let me see what C-SPAN has for us, and if there's any other announcements, but I think it's been bumped twice now, an hour each time. Nothing from C-SPAN. And so I guess we'll see what you have to say about all of this and more. It's been a beautiful day. Okay, so a couple updates. If you're just joining us, we covered 2 major updates, one from USAID. Let's check in on the USAID docket to see if there were any final updates, because this one, the last update here, Rubio sent in this notice basically saying, you got paid what you're getting paid. So we're waiting to see what the judge says. Tomorrow, we're going to be looking forward to that. So we covered that. Lots of filings there, read through some of the most recent docket drops. Then we talked about the special counsel, read through the DOJ's motion for summary judgment, and read through our Grok-created AI Transcript, which I thought was pretty dang good, pretty accurate to my recollection. So some good stuff over there. We were hoping to catch a little bit of the president. Doesn't look like that's going to happen tonight, but now it's time to hear from you. Let's see what you say about all of this and more. Sue Esponte in the house, 10 months as a membo yesterday. Happy 10 months of membership. Sue Esponte, thanks for joining on Locals and supporting us. We're grateful for you. And we got a baby. Waldo, thank you, Waldo, for bringing in Scar Scalp is here. Welcome aboard, Scar Scalp. Hey, Brian Hinkle's over here. Renee Sargent, I believe, also. You got multiple names, Brian. Gifted one membo. Sweet Blondie is coming in. Every day is Robert Day. Who is that dude? He's kind of like an ominous character there. Hey, what's up? Oh, it's Robert Sponseller. What's up, Robert Sponseller? Justin Schrank is coming in as a new membo. We got KM coming in. What's up, Richard House? Welcome. Code Red is here. We got Kelly R also making it in. Thank you, Robert. Spawn Seller becoming a membo and bringing in 5 more membos. Thanks for doing that, Robert. Hey, Summer Golden. Is Matt Gaetz now the special prosecutor for cash? I have not seen anything about that. What would he be a special prosecutor for? I haven't seen anything on that, but I might have missed it, so I could be totally wrong. But thank you, Summer Golden. I don't know. Thank you for being a membo here for 17 months, 2 months, 1 month to go, and then we got a full baby in the house. 2 full babies. Oh my goodness, that's so many babies. Thank you, Summer Golden. We appreciate your support here. Chubby Stubby on Local says, the unmitigated gall of these biased and power-hungry activist judges just turns my stomach. SCOTUS just sitting there, watching these judges overstep their judicial authority and unconstitutionally hinder the executive is driving me nuts and souring my opinion of them. They're letting it go for far too long at this point, in my opinion. Yeah, we're going to see what SCOTUS does today. I thought the same thing. They're just going to let this judge yank them around. Amy Berman Jackson, I need 3 more days. I'll get you back to you on Saturday. What? It's ridiculous. Hey, Sammy Girl. Thank you, Sammy Girl, for supporting us and becoming a membo. We'll see you tomorrow on the members only morning stream. One more reminder to our membos. We'll be 1 hour early tomorrow, and we're going to keep it nice and tight to 1 hour because I've got an event starting at 9 a.m. my time, which I will be attending. Thank you for that. David Webb, you too. Thank you for joining us, David Webb. We appreciate you being here. Fred Petamonte is in the house says, I bought Johnny great food today. Thank you to Knox Bierman, rather. KB is just very formal on that one. Knox Bierman sent in some mega love to Fred Petamonte, and we're appreciative to Knox Bierman for that. Glad you got some good food there, Fred. Hey, EOD Cookie. Can the SCOTUS step in with Dellinger, or will they just let ABJ continue to make a mockery of the Constitution? Well, they're there. Like, we're waiting for the Supreme Court to do something. Like, we're waiting for today. They literally said they're waiting for what happens today to do something. So we'll see what drops from them. Thank you for that, EOD Cookie on Locals. What's up, Knox? Speaking of Knox, says, happy hump day, all. We are working hard in Harris Co. courts this week. Looking forward to Friday. Good, Knox. Stay busy. Says, love this, and he gives total credit to the First Lady. Says, President Trump stops in to say hello to the first official White House tour group of the year. Great clip. If you haven't seen that, Trump popped in. They opened up the White House again, and that's good news. We got a topless RFK in the comments. He looks good, man. He looks good for being, well, it's like 70-something. Hey, Knox, this chub governor, and the other picture is of Governor PB&J Pritzker, from the dangerous health ideas. Yeah, he's going to save us from poor health. Thank you, Knox. We try to avoid nipples on the channel. That's why I'm not sharing that one. It's our general rule. No nips on the stream if we can avoid them. Hey, what's up? It's not my place to question the wisdom of the goddess. Shout out to Mountain Goddess for bringing in 5 new membos. We got James McAllister's coming in. What's up, Jonathan Haynes? Hello, Floppy. Welcome in. We got Brian Clark, and ammo is currency. Certainly can be. What's up, Mountain Goddess? Thank you for bringing in 5 new membos. We'll see you guys tomorrow morning early. Darren McDaniel, you too. Welcome aboard, Darren. Thank you for signing up and supporting our work. We'll see you in the morning. And grab the stream from this morning. New membos, if you missed it. Had a great stream this morning. Zone Girl says, it reminds me of my supervisor who did not understand here to the fore, but hence. Tried to tell me I was doing it wrong. Sounds like this judge cannot read and comprehend. Heretofore, but hence. Yeah. So sometimes those words can be complicated. Yeah. Thank you, Zone Girl, for that. Hey, Stephen Mosher says, time to strip the DC Circuit Court of jurisdiction. It's pretty bad. It's bad. And they're just throwing a temper tantrum. And it's very shameful to watch them do that to the justice system, but they got nothing else. It's their last hurrah. This old guy says, Judge Amy Jackson presided over the Roger Stone case, the Benghazi wrongful death case against Hillary, which she dismissed, the Paul Manafort, Rick Gates cases brought by Mueller. She has been reversed twice by President Trump, pardoning Manafort and Stone, and has been blistered by Trump on Twitter in the past. There is obviously no love lost between President Trump and Amy Berman Jackson. Great comment, this old guy. Those are some good details. I didn't realize that, but yeah, DC is just a cesspool. Thank you, this old guy. Great comment. Sheila the Pooh, a million hugs to you. Thank you for bringing in 10 membos. Sheila, you rock. We got Cheryl Sneed Gebby, David Wood Mancy. We got James Jello Lown, Trevor Craig, Philip Callan, S. Edmark, Sprinkles is here, Far Isle, Michael Mud Dragon, and Ryan Murray, KOFC. Gifted membos courtesy of Sheila Pooh. Thank you, Sheila. And Sheila also dropping a comment. Like, share, and gift if you can, and subscribe. It's well worth it for the membo-only streams. Thank you, Sheila, for saying that. We really deliver for our membos. We do streams 5-6 days a week. Some days we miss because we got other events coming up, but we're pretty consistent on it. We try our best to make it fun and deliver new content that you're not going to get elsewhere. And there's a great community there too, right? Part of the reason you become a membo is because it's a little bit more exclusive. You get to meet people. It's fun. So come sign up. Leonard, Rob, I have an idea. In response to the SNL skit, MAGA people should shake the hand of every black person that they encounter. That's an interesting concept, Leonard. I don't know. I mean, it might be interesting. It might be an interesting thing. I mean, I don't know. Black people might be like, what the hell is everybody coming up to me for? You know, like I imagine if I'm a black guy, it's like, I just want to be left alone. Can I just get to where I'm going? Everybody walks up. Sir, I'd like to shake your hand. For what? Get away from me. But it's a nice idea, Leonard. I know it's coming from the heart. Deborah Myers, what's up? Gifted one new membo. Thank you, Deborah, for doing that. And Raiden Sama is coming in the house courtesy of Deborah Myers. Thank you, Deborah, for doing that. All right, let's see who is joining us over on X before we wrap it up for the day. We got, hey, what's up? B. Torn is saying Robert Barnes is blowing a gasket. Well, you don't want to be on the wrong side of a Robert Barnes blown gasket, that's for sure. Hey, Fred Pedamonte says Amy Berman Jackson, Amy Coney Barrett. Is there a difference? Johnny just ate. So Fred Pedamonte and his rascally boy Johnny in the house. And Knox, thank you for taking good care of these two. We love Knox Bierman in the house. And we love Johnny and Fred. Hey, James, what if Trump set up a special counsel to investigate the DC judges? Esands, hey Rob, my DEI show in Dublin just keeps getting publicity. Jim Jordan just mentioned it. That's amazing. Only sold 2 tickets to an elderly couple. Payment's been delayed. And you have a lab mouse coming from Wuhan. Wow. It's going to be sounds like a wild experience over there. Jody, Rob, I feel like a lot of our federal judges should be natural born citizens to hold office, just like the president. Your thoughts? Yeah, I like that idea, actually. Yeah, because we're seeing an interesting pattern emerge where guys like Judge Mercan, Judge Chutkan, and I got to double check on Chutkan, but Judge Amir, many other judges are just like from other countries. They come in here, they're like, oh, your constitution's kind of crap, so we're going to change it all and take control. Enjoy, America. And I don't appreciate that. So I'm not sure what the exact solution is for all of the judges in DC, but a solution needs to happen because what obviously is happening right now is unconstitutional. And it may not be anything like that. It may just be the Supreme Court coming out, setting down a bright line about nationwide injunctions or whittling through each one of these cases one by one until we get to some logical conclusions. But the judges are acting, in my opinion, unethically. They're acting insurrectionary, and we're paying close attention to that. So, my friends, we are going to leave it there on the day. We're going to head over to watchingthewatchers.locals.com. President Trump just bumped his event 40 minutes from now, so 5:30 my time, 7:30 Eastern time, and we'll hit the highlights on that tomorrow morning on the Membo stream, and then we'll have updates on the rest of this stuff tomorrow, and there should be a bunch of stuff breaking because we've got a deadline tonight. Rubio sounds like submitted their final notice to the court. What happens next will be up to the judge. If he issues an order to show cause or sanctions or something, it's going to get lit, and we can't wait to get to it. So we'll pause right there. I want to thank our amazing mods and meme smiths on the day who mod the fort down for us and keep things oh so nice and beautifully. Our amazing friends, K Bean, Donut Mind Me, Carrie B, Playin' Hooky, Dog Digger, and Janik, keeping things so beautiful and nice and orderly around here. We are now pausing. We're going over to watchingthewatchers.locals.com. And we'd love to see you there. We're going to debrief for a little bit. And of course, Membos will be back in the morning to get into it again. Otherwise, my friends, it is going to be a great and beautiful night. Thank you so much for joining us. Thank you for subscribing to our channel, for liking the video, for inviting a friend or family member to come on over and join us, because we're going to be back here tomorrow. We're going to get into these TROs, these injunctions, and the rest of the nefariousness. And in order to do it appropriately, we're going to need to see you right back here so that together, with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful night, my friends. Sleep very well. I'll see you right back here tomorrow. Bye-bye.